Today we are looking at the pros and cons of having an internal appeal policy and procedure as a small business owner. While this is not mandatory by law, you can opt to have it or opt not to have it. But to reiterate, it's not mandatory by law. So we do this by looking at the case of Nkuna versus Eskom. So Eskom had an internal appeal policy and procedure that stated that whatever the chairperson of the appeal finds as a recommendation, the employer shall be bound by it. So in this case, Nkuna was dismissed, and then Nkuna appealed against the dismissal, and then the chairperson overturned both the guilty finding and the dismissal, stating that it was as if the employee had never been dismissed. The employer, however, refused to accept the appeal outcome and insisted that the employee remains dismissed. And then Ms. Nkuna approached the High Court, relying on the breach of contract. And then the High Court found that the dismissal was unfair and ordered that the employee be reinstated, and stated that the policies and the procedures, they form part of the employment contract. So, key takeaways is that an internal appeal is optional, not mandatory. So you are not forced as a small business owner to have an internal appeal process. Just make sure that your disciplinary processes are procedurally fair and the outcomes are substantively fair as well. And then avoid using words that create obligations on you as the employer. And then the last one, if you decide to include an appeal process, make sure that your disciplinary policy is carefully drafted so that everyone's role and powers are clear. And then bottom line, a good disciplinary process is better than a complicated one. So you are not obligated to have an appeal process, but I prefer it in the sense that if there's something that one chairperson overlooked, then another chairperson can possibly pick up. But at the same time, it can be costly for small businesses.